2 days ago.
Is about 3 weeks time. That's last chance to perform. List up to 2 weeks. Interim is there? Interim order passed already until the next meeting. Actually. Yes, Mr. Das, you are here for quashing the FIR.
My
Resolution
lord,
notice.
yes, that's what,
Yes.
my lord, your lordship will only, I am praying for issuing a notice only. And your lordship will ask the state that the case diary should be produced before the court.
Yes.
Because, my lord, what I will tell your lordship one thing, my lord, your lordship item number 7 and 8 are also 7 and 8.
Yeah.
7 and my lord,
Today's list.
today's list.
Today's
7 and
list.
8, my learned friend is appearing.
Here
In
was
7 and 8, 1 second, my lord.
Ah,
So we first.
it's good to see you both here.
So, my lord, we filed the 7(8) first, that question of section 8 application, which has been, notice has been issued by ED to us.
Yeah.
We said that this is out and out without jurisdiction. This is one. So, my lord, this is one where there was some interim order was protected by the court. Now, second, my lord, in that petition, we sought for question of the ECI.
Ah.
ECI. We sought for question, then there is an order which has been passed by this court. No coercive measure, but further investigation, they can go ahead. This is what is happening. Now, why I filed this FR question, when they filed affidavit vacating of the order and 17 for application, we found that absolutely there is no predicate offense so far as the first FIR is concerned.
Okay, we will consider all those, we will consider.
Yes, my lord will issue a notice in this case.
Your
And-
lordship,
Yes, sir.
I am appearing for the respondent numbers 2 and 3.
2 and 3
Those
in the present rate petition.
in the first item number 1, that is the enforcement directorate.
Okay, okay. 2 and 3, let us see. This is for the government?
There is a private respondent as well.
2 and 3. Okay, 4. Let's seek for a direction to transmit all the reports.
Yes, that's what my lord, I just want to say.
Is it
Now-
charge sheeted?
No, it's not charge sheet. Now, there are two things, my lord. If this is really about why I'm approaching this court, my lord, because the ED has dragged me in this particular case because of the predicate offense. Now, predicate offense they have called me. That's why I want a declaration from the court after looking the case diary. So I am saying the transmitting of the records, your lordship will look into it. What is the role of the particular petitioner, quasi petitioner in this particular case? That's why.
And it is for the prosecutor to produce the records.
Yes, they
It
will
is for
have
the prosecutor.
state of Nagaland.
Correct.
Yes.
May I please, my lord?
Yes.
My lord, if recordings to be called, a direction may be given to produce the scan. copy
Yes,
of-
we are directing on a scan copies. We are not stopping anything. We are not stopping at this stage. Yes,
Lordship, I have filed the application for vacation of the interim order in the other case.
in that other case.
If your lordship will clarify that we can go ahead with the investigation, because lordship, investigation cannot be stayed as it is. And so far as quashing is concerned, lordship, the law is well settled in the case of Bhajan. Some parameters have been laid down.
Correct.
So I leave it to your lordship will examine the records. But so far as the other case is concerned, lordship,
Other cases listed today.
yes, item number 7. And
Hmm.
my only prayer before your lordship would be, let there be a clarification that, all right, the investigation can proceed. Because if the investigation is stalled, and right now, the accused is fled from India. He is in Dubai. So we have to collect the evidences, we have to investigate. Therefore, investigation may be allowed to continue.
There are two things I will just try to submit for lordship. So far as the other case is concerned, your lordship, I draw your lordship attention. There is no order from the court that investigation should not be stalled.
Let us see that.
Yes, that's why.
I have Mr. D. Das, learned senior counsel, assisted by
Yes, does.
Mr. So-and-so. Also have Mr. Kiangami, the learned public prosecutor for the state respondent number 1. And Mr.
RKD Chaudhary.
R.K. RKD,
B.
RKD Chaudhary,
I'm deputy SGI,
the learned
deputy SGI. So is it-
deputy SGI
Lordship.
for the respondent number 2 and 3. This application has been filed under Article 226 of the Constitution of India, read with Section 482 of the Code of Criminal Procedure, 1973, for quashing the proceedings against the petitioner arising out of Kohima cyber crime, PS case number 03/2021. Under section 120B/420 IPC, read with section 66D of the IT Act. Issue notice to the respondents, returnable within 4 weeks. Since the state is represented by Mr. Kyanlami, the learned public prosecutor, and the respondent number 2 and 3 is represented by RKD Chaudhary, the learned deputy SGI,
Deputy Solicitor.
deputy SGI.
Yes.
No formal notice need be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned counsel for the respondents within or in the course of the day.
Two days.
No,
Monday,
no,
by Monday, we'll do it, Monday.
within a period of 4 days from
Yes.
today. In the meantime, the learned public prosecutor shall produce the scanned copies of the FIR relating to Kohima cybercrime PS case number and the scanned copies of the case diary in the said case. Okay, listed after?
My lord, we'll take a justice service on respondent number 4.
Yes.
That's a private respondent.
Okay, listed after 4 weeks. The learned counsel for the petitioner shall take steps for service of notice
My lord,
upon.
what I will just pray, if it is not inconvenient to your lordship, can it be after 2 weeks? Because case diary only scan copy. Scan copy is got, because now, why this next to, the other case is directly involved with this, that's why I am saying.
Upon respondent number 4 by registered post with
Yes,
AD
sir.
within a period of
Dusty will take a dusty also.
for
Register
service of
post as well as
notice
dusty.
upon the respondent number 4 by dusty process within a period of
No, this is, he's from Delhi. He's a lawyer from Delhi.
so the dusty
2 weeks.
process,
Within
dusty process within a period of 10 days from today and shall file affidavit to that effect.
Yes.
You will list it after 4 weeks.
My lord, the problem is that suppose that two case, I don't know what my learned friend will say about your lordship will about these two cases, other case, writ petition which we filed for question of the ECR and suppose tomorrow your lordships, the records are called for and I, there is no predicate. of-
Okay, list it after 3 weeks, okay?
2 weeks, my lord.
List it after 3 weeks. Okay,
Lordship,
yes,
can it be?
or we have a fixed date.
Can it be in the week commencing 11 September? Because Lordship, in between, I will be out of station.
Okay. 11 September. We are listed after 3 weeks. That will be commencing after 11 September. Okay,
Other case, the lordship is similar,
which is
7 and 8.
IA.
Yes, sir, earlier this is my learned friend is filed for vacating, but we have to file an affidavit in this main case. Two things, well, my learned friend is saying that the investigation has to go on. There should not be any halt of the investigation.
Let's see this.
Kindly see the 36/2023 order.
In the IA. In the IA.
It is annexed
Mr.
in the
Das.
IA, Lordship. It is annexed in the IA at page 27.
Mr.
Four eight. Four eight is also annexed, Lordship. I'll take your Lordship. Page 22. It starts-
See the 4-8 order.
Is there any order staying the investigation?
Lordship, there is an order that no coercive steps will be taken now.
No course of steps.
Now, thing
I
is,
will kindly see 36 order is her learned council 36 order.
36, which,
36,
in
that
which,
is at page 27.
In this case,
in
In
IA.
IA.
in page,
Operative part starts from page
no,
27.
in page.
no, Lordship will take this file.
uh, Where is the order annexed? In page,
That in the IA Lordship, it is at page 26.
okay.
Kindly see the order of 36.
Page
My lord
26.
will trouble, I am.
Just wait, wait.
Kindly the order sheet.
Wait, make overlapping submissions.
Order
Just
sheet.
wait,
Yes,
26,
36.
26.
Of the IA. I'm on the no coercive steps. It says it may continue, but no coercive steps means Lordship. The Honorable Supreme Court has clarified, Lordship, that there cannot be any order like no coercive steps. And that has been laid down in the case of Niharika Infrastructure, Lordship. I have quoted it. At page 13. I'm sorry, Lordship, it starts at page. Page 8, Lordship, paragraph 7. Now, if we cannot have the attendance of the accused person
You're for which respondent in this IA?
for the ED, Lordship,
For the
I'm for the petitioner in the IA, applicant in the IA,
applicant.
applicant in the IA.
And this direction is issued to
Issued to us,
the directorate enforcement
yes,
and the deputy director,
yes.
2 and 3. The assistant director,
So,
assistant director, 3.
yes. Lordship. Now, if the court says that investigation may continue but no coercive step, how can we investigate, Lordship? And whenever an order of no coercive step is passed, the honorable court has to give the
Okay,
parameters.
we are modifying it.
No, your lordship is modifying, your lordship has to hear the order.
Mr.
My lord, 1 second, my lord.
RKT Chaudhary.
1 second, my lord. My lord. Your lordship is that already there is an order passed by this court on 36. Kindly see the order of 36.
Here, the minute,
Yeah, that's why I told-
Deputy Solicitor General.
I'm sorry, my lord, your lordship will kindly hear it, my lord. What
And
I want to
also-
say, that no further investigation, further investigation will continue.
Mr. Here, who is the applicant? You are not the
And
applicant.
the applicant in the IA.
IA, they filed for modification variation of the order of 36. My lord, 36, what the court says, my lord, no coercive action taken, interim order passed, so
And Mr. D. Das,
investigation will go on, my lord.
Elder Senior Counsel. For the respondent.
They will not challenge the 4-8 order also, my lord. They have to challenge the 4-8 order.
Stop. The present application has been filed. Praying for vacation / modification / alteration of the order dated 1/6/2023 and 36/2023. Passed in WP within bracket CRL number 3 of 2023. After hearing the learned counsel for the parties, the order dated 36/2023 is modified to the extent that the said order shall not be a bar for the applicant to conduct investigation.
That, Lordship, that is the only, Lordship, I needed a clarity. Because I have quoted the order of the Honorable Supreme Court in paragraph 7 of my.
It's all good.
Supreme
My
Court
dear
says that if-
Lordship has to hear them. So you argue, I will give a reply.
if
My lord, Niharika, there is other judgment where it says, my lord, there is already an
But
order.
actually, Mr. Arkidi, this does not bar you from conducting investigation.
Lordship will kindly consider one thing. I made a submission, oral submission. The accused here is not in India. He is in Dubai. I have got to summon him from there. Now, if I issue a summon,
Okay,
whether
what
that
was the
will be a
last line?
coercive step
What
or
was the
not.
last line?
Someone cannot be a coercive step, my lord.
Okay, yes. Cannot be here.
Lordship will clarify that I can summon him, I can interrogate him.
Cannot be here. For the applicant 2, 3, and 4. For the applicant number 2, 3, and 4. To conduct investigation in the case against the respondent.
Lordship, that was their lordship. I may be allowed to summon him or question him, lordship. He is.
You are
sitting
given that
there.
liberty. Given that liberty, see,
On the court.
investigation, we have given you the liberty to investigate. We should also include your power to summon him. We are not stopping you. We are not stopping you. Why you want that specific word that you should be allowed to summon? I think when we have modified the order, stating that actually the order dated passed earlier shall not be a bar for you to investigate the case against the petitioner. I think that includes everything. That's
I'll leave it.
listed after.
Let it be together, lordship.
Listed after.
Let it tagged on after 3 weeks, my lord. Together with that case.
Okay, listed after 3 weeks.
With together with this case, first case, sir.
Let this case be tagged with
With item number 1, my lord.
yes, with WP within bracket CRL 6/2023.
Lordship.
Okay,
Lordship.
My lord, 1/6/2023, there is an order in section 9 that will continue. 1/6/2023, that order is there. Section 8 application that has been stayed time and again by the court. So that will continue.
But-
Rest they will go for him.
Lordship.
No, that cannot be. Then your lordship will carry here. This is, they
Lordship
cannot
will
do
hear.
it, my lord.
Lordship will hear.
But that, how can they stop it, my lord? 1/6 my
Lord,
lord, their lawyer, he
see,
will appear.
let us hear everything at one go.
Yes, one.
When the
go.
petitioner is,
So,
when
like
the
it be
petitioner is
1/6
listening.
has to continue.
And when by modification of the order today, since you have been given the liberty
Yes.
to conduct the investigation.
Already, sir, let it be, my lord. All these matters should be heard together and the interim order pass will continue. They have been given by the court liberty to investigate.
Here,
How can they say that liberty is
here,
not
lordship,
given?
if the proceeding under section 8 is stayed, let us assume, here he has come up in the earlier writ petition challenging the notice, show cause notice issued by the adjudicating authority. A show cause notice cannot be challenged, is my submission,
Let
because
him argue, my lord, I'll give a reply. Let
because
him argue.
My friend gets offended.
No, I think,
You have to argue.
let us hear everything.
Everything. He-
On merit, on the next fix.
Yes, why I get offended? He filed an application.
Today,
You have-
I have actually considered your application to the extent of modification of the interim order. So you can go ahead with the investigation.
Main petition.
So the other issues, I think it will need a extensive hearing.
But that order 1/6 should be extended, my lord. Two interim order has to be extended, my lord. No investigation, there is a, that's what kindly look into what is the order that has been passed. For investigation will go on. I told the court, open court, my lord, I am asking, I told the open court, my lord will not take over investigation. But they will not take any coercive measure, investigation has to go on. That's the order which was passed by this court. So earlier order of 1/6, my lord, the lawyer was not present before the court, in spite of the notice. My learned friend was not there. On 23/5/2023, I came before this court. When I challenged section 8, I told the particular judge, my lord, with great respect, said, please don't pass this order because these are important matters. I am not asking for any interim order. Your lordship will kindly see that's a recording of my.
What was the order passed?
That order was passed.
In which item?
Kindly see, in that case,
It starts at page 22. now.
petition 3 man.
Which is that? Oh,
My lord, kindly see the first order
order, which is that order?
of 23/5/2023.
Where is that order?
23/5/2023.
23 by. There runs.
23/5. Kindly see, my lord. Mr. Das, learned senior, assisted by so and so. Read petition has been registered on filing an application under Article 226, read with section 482, praying for issues appropriate in the nature of mandamus searcher against respondent. And on the question of the notice dated 16/3/2023 issued by adjudicating authority to the present petition in original AO and also further reliefs as paid for by it is stated by learned counsel petitioner that copies of writ petition notice were already served on learned special counsel for enforcement director as well as learned central government standing counsel. So and so learned has submitted that YB Gupta is indisposed and hence pays for listing the matter about 4 weeks. However, on this Mr. Das learned has submit as the matter is urgent, submission of learned senior petitioner may be heard in part today and the matter may be fixed on 21/6/2023 for further hearing at motion stage. Learned counsel appearing on behalf of so and so. Enforcement director, learned counsel appearing on behalf agree to the said proposal. Mr. Das, learned senior for the petitioner, having remains inconclusive at motion stage. Hearing shall continue at motion stage on 1/6/2023, on which date the learned special counsel ED as well as learned central government standing counsel remain present in the court. The interim order shall be considered on the next day, that is 1/6/2023. Now kindly see the order of 1/6/2023, my lord. Kindly see 1/6/2023 order. Second paragraph appears from record on the last day, that is on 23/5/2023. Learned counsel appeared on behalf of Mr. Gupta, learned special counsel for enforcement directorate, and prayed for some time. It also appears that on that day, petitioner served extra copy of petition to the learned special counsel for enforcement directorate as well as learned central government standing so as to enable them to seek necessary instruction from the respondent. It was also requested learned special counsel for enforcement director as well as learned central government standing counsel make themselves available before this court when the interim prayer for the petitioner would be considered. However, today, though so and so learned government standing counsel present, Mr. Gupta is not present. The criminal petition has been filed by petitioner alleging procedure irregularities by respondent, namely respondent number 4, in violation of the procedure prescribed under section 8(1) as well 17(4) of PMLA Act. The petitioner has paid for setting aside the notice dated 16/3/2023 issued under section 8(1) as well as application on section 17(4) filed by so and so.
In writ petition criminal 3, 2023, okay? Okay. Heard Mr. Didas, the learned senior counsel, for the petitioner, and Mr. RKD Chaudhary, the learned Deputy SG. For the respondent number,
Lordship in the
All the respondent is appearing. 2, 3 and 4.
2, 3 and 4. 2, 3 and 4. Stop.
2, 3 and 4.
Sure, sure. The interim order passed earlier shall continue till the next returnable date.
Lordship is fixing it after 3 weeks. Both the
I
cases,
think we fix it.
both the cases will tag together.
We have passed an order
11.
that this petition should be listed along with WP criminal 6/2023.
Lordship.
Yes, on.
Okay, after 3
Lordship will
weeks.
fix the date.
So they can fix a date, my lord.
Fix a date.
Yeah.
Okay, fix it on.
It's fine.
11.
Fix it on.
11th of September.
You will be there Monday.
Yeah,
You will not be stuck up there.
no, I save 1 week. Like welcoming.
Not 15, let it be 15 is Monday.
15.
15th of,
15 is not Monday.
no,
15
no,
is Friday.
15th is Friday.
11 it can be fixed. 11 is.
11
11th is fine. Okay.
listed on 11/9/2023. Okay,
Obliged.
I am deeply obliged.
yes.
Yeah, please, your lordship.
Yes, Mr.
My lord, this matter pertains to non-consideration of regularization of the petitioner in service. He has served in the department as vendor for the last more than 32 years of service. But till now, his service has not.
Mr. M. Kongjamya, the learned counsel for the petitioner, and Mr. Moimchin. No, I'm sorry. M. Kongjamya, learned counsel for the petitioner. Stop. The petitioner was appointed as work judge Khalasi.
The scale of play.
Right order dated 8/4/1991. Under the establishment of SDO PWD Noplak. In the state scale pay of rupees 375-7-445-9-490-10-590. Stop. PM. It is the case of the petitioner that he has been serving the department for more than 32 years. But his service has not been regularized. Stop. The petitioner is due to retire on 30/4/2026. Stop. It is the case of the petitioner that the government of Nagaland, by office memorandum dated 17/3/2015, has formulated a scheme for regularization of work charge employees who has completed 30 years of service. Stop. However, despite the formulation of the scheme, the petitioner's case has not been considered, although the petitioner has served for more than 30 years in the department. Stop. The petitioner has submitted representation for regularization of his service, but the same has not been considered till date. Stop. Issue notice to the respondents returnable within 4 weeks. Since Mr. Maj Imchin represents the state respondents,
No state response.
all the state respondents, no formal notice need be issued. Stop. The legal counsel for the petitioner shall however serve requisite copies of the writ petition to the learned state council within a period of 3 days from today. No private respondents, no?
No private respondent.
Okay, listed after 4 weeks.
Much obliged.
Mr. Lordship, your lordship may kindly allow me 3 weeks' time to file counter in this matter, your lordship.
MS Inaoli, the learned government advocate. 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Much obliged. Please, your lordship, I'm
Yes.
making a prayer on behalf of AIME, your lordship. This matter may be listed after a week, your lordship.
All
Yes,
pleadings are
yes.
completed.
No, your lordship, the state respondent have sought time for filing additional affidavit on the
Oh.
last occasion.
Is it? Additional evidence, yes, yes. Office note dated 4/8/2023 shows that the additional affidavit which the state was required to file has not been filed. Listed after 2 weeks for enabling the state respondents to file the affidavit, to file the additional affidavit. Okay,
Much obliged.
No, please, lordship.
Yes.
Also, I'm making mention on behalf of my senior, Mr. Gauhati, learned CGC. Lordship, in this case, we are yet to receive instructions for respondent number 1 in Union of India. So kindly 2 weeks time will be granted.
okay,
What's the interim?
Mr. Zatan Kundu. Makes a mention on behalf of Mr. Yamawati, the learned CGC, and seeks adjournment of the case for 2 weeks to file affidavit in opposition. Where is
2
the
weeks,
law?
lordship.
Listed after 2 weeks.
Lordship.
3 weeks, no botheration for CGC.
What's the interim?
The interim order passed earlier shall continue till the next returnable date.
Obliged, sir. May I please, your lordship. Your lordship, my seniors in this post, so let the matter become of. Western General Lordship.
Mr. So-and-so submits that Mr. Estimjad, the learned counsel for the petitioner, is indisposed and therefore seeks adjournment of the case after
3 weeks.
2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
May I please, your lordship,
Yes,
I'm making a mention on behalf of the council for the responding number 2. Kindly grant us 2 weeks time to file a rejoinder affidavit to the affidavit in reply filed by the petitioner.
to the affidavit in opposition by the petitioner. Petitioner cannot file affidavit in opposition.
To
Your,
the affidavit in reply filed by the petitioner. Council for the respondent number 2.
respondent number 2, have you filed your affidavit? Yes, you have filed your affidavit in
Yes, your
opposition.
lordship.
What is the case?
Lordship, this case is relating to maintenance case, your lordship.
No, you have filed your affidavit in
Yes, Lordship.
opposition. You are the petitioner.
Yes, lordship.
Have you filed reply?
Yes, lordship.
So you want to file a rejoinder to the reply?
Yes, your lordship.
Is it that your case? You want to file rejoinder?
Yes, your lordship.
MS so. The learned counsel for the respondent number 2 submits that she may be allowed 2 weeks time to file rejoinder to the reply affidavit filed by the petitioner. Where is allowed, listed after 2 weeks.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next returnable date.
Obliged, my lord.
May I please, your lordship.
Yeah.
Lordship, I am informed that the accused person has been detained under NSA lordship. So,
And I say,
yes, lordship.
so why bail?
No, lordship, only after the bail petition was filed, he was being detained, lordship. So, lordship, kindly allow us to withdraw.
This has become in practice.
Yes, lordship.
MS so. The learned counsel for the petitioner submits that she has instructions to withdraw the application. Prayer is allowed. The bail application is allowed to be withdrawn.
Much obliged, lordship.
May I please, Your Lordship, a prayer on behalf of Supong, Your Lordship. She's yet to file counter in this matter. So kindly grant 3 weeks time, Your Lordship.
MS Inauli makes a mention on behalf of Mr. MS Sapong Chang, the learned government advocate, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed up to 2 weeks.
Much obliged.
Folks.
Committee section, court 2 over.